Welcome to rePROs Fight Back, a podcast on all things repro. I'm your host, Jenny Wetter, and each episode I will be taking you to the front lines of the escalating fight over our sexual and reproductive health and rights at home and abroad. Each episode I will be speaking with leaders who are fighting to protect our reproductive health and rights, to ensure that no one's reproductive health depends on where they live. It's time for rePROs to fight back. Welcome to rePROs Fight Back. On a previous episode, we talked about how the Trump administration is reshaping the federal judiciary. Today, with that in mind, we're going to take a look at some of the important abortion-related cases that are currently working through the court system. To explain the cases we should be keeping an eye on, I'm excited to have with me today Brigitte Amiri with the ACLU. Hi, Brigitte. Thanks for being here today.
Hi. Thanks so much for having me.
So I thought before we get to the current cases and what's working its way up, maybe we should just talk a little bit about what the current lay of the land is, what abortion law looks like right now. And I think most people are familiar with Roe v. Wade and maybe less familiar with some of the other Supreme Court rulings like Casey or Whole Woman's Health.
So let's go through the major Supreme Court decisions on abortion of the last 40 years, the last 4 decades, but it'll be fairly quick. I mean, obviously everyone knows Roe versus Wade, and people associate the Supreme Court decision with the ability to access abortion and the right to abortion in the Constitution, and that's certainly the framework that we start from. So in 1973, the Supreme Court found that the right to abortion is constitutionally protected in the 14th Amendment to the U.S. Constitution. And it overruled a number of abortion restrictions that were in place at the time that criminalized abortion and basically made abortion legal for the first time in the United States across the country. There's obviously a lot of history leading up to Roe that we won't necessarily get into, but it builds off of the right to contraception and right to privacy, and a number of states had already started reversing their abortion bans in their states, and then the Supreme Court for the entire country said that it was illegal to ban abortion under the Constitution. There were a number of cases between Roe versus Wade and Planned Parenthood versus Casey in 1992. But in 1992, the Supreme Court issued another landmark abortion decision and scaled back on what they said in Roe versus Wade. In Roe versus Wade, they said that abortion is a fundamental constitutional right, and any abortion restriction had to be considered under the highest level of scrutiny for the courts, making it very difficult for states to pass restrictions on abortion. But in 1992, the Supreme Court said that states could actually pass restrictions on abortion as long as they did not impose a substantial obstacle in the path of women seeking abortion. And that is then the new standard in 1992 that people used to evaluate whether an abortion restriction was constitutional or not. So abortion is still a fundamental right. It's still protected under the Constitution, but the test that courts use to assess whether a particular restriction violates the Constitution is whether it imposes an undue burden, or in other words, imposes a substantial obstacle in the path of women seeking abortions. And there have been obviously a lot of cases about what does that mean. And then in 2016, the Supreme Court decides Whole Woman's Health versus Hellerstedt, and it's a case coming out of Texas about doctors having admitting privileges and whether abortion facilities must meet the standards of ambulatory surgical centers. And the Supreme Court clarifies what it says in Casey in the sense that it says that when courts consider restrictions on access to abortion, they must assess the benefits of the law to women's health and balance that against the burdens imposed on women. And in Whole Woman's Health, they did that balancing test and concluded that the elimination of abortion clinics in Texas in large numbers was incredibly burdensome, and the medical benefit of having admitting privileges was slim to none. And so it struck down the Texas law. So that all builds on other cases that have come between those landmark cases, but that's where we are now.
I think that's important background because I feel like a lot of the conversation we hear is really focused on Roe, and what states have really been targeting for years is Casey.
Well, and also, too, I mean, I think that they've also been chipping away in these really insidious ways that I think a lot of people don't know about. Since 2011, there have been 400 abortion restrictions passed in various states across the country. And now we're seeing more direct attacks on Roe in terms of attempts to ban abortion. But literally since the day that Roe versus Wade was decided, states have been trying to find ways to close clinic doors, reduce the availability of abortion providers, shame women and providers, shame people who seek abortions, and make it more difficult for them. And that has been their tactic for over 40 years now. And, you know, in a lot of places, it's as if Roe versus Wade was never decided. Roe does not mean anything if there isn't the availability of a provider. And there are several states now where there's only one abortion clinic because of these restrictions that have built on top of each other that have eliminated abortion access in the state to the point where there might be only one provider.
Yeah, and they tend to build on each other. Like a lot of that is in the South. So you have states near each other that only have one. So you don't really have another alternative for somewhere to go.
Well, that's right. And also everybody should be able to get the care that they need within their state.
Absolutely.
And not have to travel out of state. And it's really frightening that in these several states that there's only one abortion provider, and in the South, but also in the Midwest, Kentucky, Missouri only have one abortion provider. North Dakota, South Dakota only have one abortion provider. Mississippi only has one. So you know, they're somewhat scattered. And then when you look at the map and you see the states that are adjacent to these states that are also trying to restrict abortion. You know, Kentucky has one abortion clinic remaining. In the 1970s, after Roe was decided, there were 17 abortion providers or hospitals that provided abortion. And now today there's only one place where you can get an abortion, and that's EMW Women's Surgical Center in Louisville. And the idea that, you know, putting aside that everybody should be able to get the care that they need in their state, if you look at the map, there are a number of restrictions trying to close clinics in Indiana, Ohio, Tennessee. The House just passed a 6-week ban. Ohio is poised to pass a 6-week ban as well. So it's there's one provider in West Virginia, which also borders Kentucky. So it's really a difficult picture when you look at it from that bird's eye view.
So I'm originally from Wisconsin, so I've been watching access dwindle in Wisconsin too. Hopefully that'll change with the new governor, but I think right now Wisconsin has 3 clinics left, and they're all in Madison and Milwaukee, which is very southern Wisconsin. So there are large swaths of the state that don't have access.
That's right, and I think that's a really important point. That where clinics have been able to remain open, they have been in urban areas. And so for rural women, in particular, low-income women, marginalized communities, it makes it very, very difficult to travel to the abortion provider in an urban center because people lack the money to do so. They can't take time off of work. They can't find childcare to care for their existing children while they make the journey. And that's an incredibly important picture of the difficulty in accessing abortion today.
So moving forward to talk about the cases. So a lot of the cases were really aimed at trying to find where Justice Kennedy was on where was he placing undue burden. That was kind of what the aim felt like for a long time. But everything changed last year with the appointment of Justice Kavanaugh. So it's good to now move forward and start looking at what some of these cases that are coming through the pipeline could mean going forward with this change in the judicial landscape?
As you know, President Trump vowed to appoint justices that were committed to overturning Roe versus Wade, and so that is a deep concern that now that there are 5 out of 9 votes to overturn Roe versus Wade, and nobody has a crystal ball, and we don't know exactly what will happen in the future when one of these cases gets to the Supreme Court for consideration. But it's really frightening in terms of what the possibilities are, and we're obviously, involved in litigating a number of cases, some of which may get to the Supreme Court, and what the court will do with them is really kind of anyone's guess. There have been a couple of small clues that people are trying to draw from, and I think that trying to read those tea leaves is not necessarily helpful. Like, it doesn't really tell us that much. So, the Supreme Court has denied review in a couple of abortion cases, but I don't think that necessarily means that they're not going to accept a case at some point and either weaken the right to abortion or overrule Roe. And quite frankly, one of the really concerning possibilities is that the Supreme Court is going to weaken Roe versus Wade, allow some of these restrictions to stand on the books, eliminating abortion access in some states, but not saying that they are actually overruling Roe. And so I think everyone really just needs to be paying very close attention to not just the direct assaults on Roe and the possibility of Roe being overturned, but Roe being gutted such that it really means that there is no access in some states.
So I think one of the places to start with some tea leaf reading is one that is very close to Justice Kavanaugh, and then very close to you because you were one of the lawyers arguing it, and that's the Justice for Jane case.
Yeah, so the Jane Doe case involves the Trump administration's attempt to ban abortion for unaccompanied immigrant minors. These are young people who come to the United States largely from the Northern Triangle in Central America and are looking to flee violence in their home country, sometimes at the hands of their parents. And if they are detained in the United States, they are put under the care of Health and Human Services. And in September of 2017, we learned from one of our fantastic coalition partners, Jane's Due Process, that there was a young woman in custody of HHS who was seeking access to abortion. She had gotten a judicial bypass in Texas, which is required if you are not able to get your parents' consent. You can go to court and ask a judge to allow you to consent to the abortion on your own if you're a minor. And she had done that hurdle, and the Trump administration ordered the shelter where she was staying to not allow her to leave the shelter for any abortion-related appointments. So we had to file an emergency lawsuit, and we got a quick ruling saying that it was blatantly unconstitutional for the Trump administration to ban access to abortion for this brave young woman. And the government appealed, and on the initial appeal panel was then Judge Kavanaugh in the D.C. Court of Appeals. So I argued that case in front of Judge Kavanaugh and 2 other judges, and Judge Kavanaugh wrote for 2 of the 3 judges after argument saying that the government should be allowed to have more time to find a family member in the United States who Jane could be released to, such that she could get the abortion outside of government custody. And that ignored that the government had already been looking for 6 weeks for a family member for her to be released to and wasn't able to find one, that the government had already essentially held her hostage for 4 weeks after she requested the abortion, pushing her further into her pregnancy against her will, and that the government can't ban abortion for anyone. And so Judge Kavanaugh really ignored the basic fundamental rule of law of Roe versus Wade.
And they definitely seem to be running out the clock, too, because didn't Texas have a 20-week abortion ban?
That's exactly right. And I said that at oral argument, and at the time she was approaching 15 weeks. So giving the government 11 days to find a family member. And then at the end of those 11 days, it's not as if Judge Kavanaugh said she could get the abortion. He said that we could start our case all over again in district court, get a new order saying she could get the abortion, which the government could then appeal and make the same or new or different arguments. So we would have to then start the case all over again, which would further run out the clock. And we said that's completely unacceptable, and we asked the full Court of Appeals to overrule Judge Kavanaugh, and they did. And Jane Doe was able to get her abortion about a month after being delayed by the federal government in terms of the initial being blocked initially, and then fighting us tooth and nail in court. And so that Judge Kavanaugh decision, really raised a lot of alarm bells for us in his appointment process, and we explained that we were concerned that he would not follow Roe versus Wade, at least not exactly say that, but do this sleight of hand and try to say he was following the rule of law, but really not do so. And so that was the concern that we were raising at the time. And then we can kind of that segues into June, I think, a little bit, if you wanted to talk about June. But or I can go back to talk about where the Jane Doe case is. So we there were a number of other young women who came forward until we could get a order that prohibited the government from obstructing or interfering with access to abortion for the entire class of pregnant unaccompanied immigrant minors in federal custody. So we went to court one by one for each of those young women. There were 3 other young women in addition to the original Jane Doe. And then in March of 2018, we got an order from the district court saying that the government was prohibited from interfering or obstructing with access for any pregnant unaccompanied immigrant minor in their custody. And that's when I finally was able to sleep through the night. Yeah. And the government appealed that, and we had oral argument in September of 2018. And we are awaiting a ruling. But in the meantime, the government is blocked from interfering with access to abortion, and I hope we will win in the Court of Appeals, but then the government could petition the Supreme Court for review. So to the extent that people are watching what cases might come to the Supreme Court, there is a possibility that when hopefully we win that case, the government will petition for a review, and then that will be one of the cases to watch in front of the Supreme Court. And
then, you were right. Like, the next tea leaf was the Louisiana case, the June case. It was good news, but like you said before, I don't know that bodes necessarily that I think positively going forward if they were to hear the case. It's just temporary good news.
So the June case is the Center for Reproductive Rights TRAP case out of Louisiana, and it poses very similar questions that Whole Woman's Health did about doctors who provide abortion must have admitting privileges. And the law was blocked by the district court, and the Fifth Circuit Court of Appeals reversed that decision and basically tried to get around Whole Woman's Health in a very disingenuous way. And the Center for Reproductive Rights asked the Supreme Court to block the law from taking effect while they petitioned the Supreme Court for review. And the Supreme Court agreed to do so to prevent the closure of all but one abortion provider in Louisiana, I believe. But in that tea leaf reading was Justice Kavanaugh, now Justice Kavanaugh, who writes a dissent saying he would allow the law to take effect. And as soon as I read it, I was shocked, or not shocked, I shouldn't say shocked, I'm not shocked by much these days. I was struck by how similar his dissent in the June case was to what he wrote in Jane Doe. This lip service to precedent, this lip service to the rule of law, but not adhering to it. The Supreme Court had just decided Whole Woman's Health in 2016, striking down admitting privileges, finding that there was no medical benefit to have them, and finding that it would close clinics. So what is the difference between that ruling for Texas in 2016 and Louisiana in 2019? And the answer is none. And the fact that Judge Kavanaugh tries to explain his reasoning away was a further indication, I think, of where he's going to be on abortion restrictions. Chief Justice Roberts votes with the majority to block the law from taking effect. And so now I think folks are opining on whether Chief Justice Roberts is, in essence, the new Justice Kennedy, the swing vote about whether an abortion restriction should be upheld or not. And I think you're absolutely right to say that this doesn't really tell us much. This was an emergency order about whether a law that was very similar to one that was struck down 3 years ago could take effect while the Center for Reproductive Rights could petition to the Supreme Court for a review. And it really doesn't tell us anything substantively on how Chief Justice Roberts is going to rule on an abortion restriction when a case comes to the court fully briefed, fully argued on the merits.
No, I think that's right. And I think, it seems like he's the swing in so much as that I think he might have an inclination to be a little more cautious, but not necessarily like he's already going to be much further right of where Kennedy was. So it's not swing in the same way that Kennedy was.
Yeah, I just think we just don't know. And I think that people shouldn't read too much into this one way or the other, and time will tell. And there are a number of cases that are in the pipeline. So obviously, the Center for Reproductive Rights, will petition for review in the June case. But also, there are a number of cases that are pending in front of the Supreme Court in terms of petitions that are already up there, including an Indiana case brought by Planned Parenthood and the ACLU challenging a restriction on the reason why women seek abortions. The Supreme Court is considering whether to take that case. The law was struck down in Indiana, saying that it was unconstitutional to ban abortion because a person was seeking an abortion based on a diagnosis of Down syndrome of the fetus. And the Supreme Court hasn't decided whether to take that case or not. Also up for review is our case challenging the Alabama restriction on a method of abortion. The Supreme Court will also just consider whether to take that case.
Yeah, I think that you're seeing so many different lanes of attack right now where anti-choice advocates are just trying anything they can to try and ban abortion. So we talked a little bit about trap laws, and there's other trap cases that are pending. There's also method ones that are pending, which is you just mentioned. Do we want to talk a little bit about the GMW case for transfer agreements?
Yeah, and it's actually the brief that I'm working on right now is that one. So, Kentucky is a perfect storm of what can happen in the worst case scenario in many ways. So as I mentioned before, Kentucky is down to one abortion provider, EMW Women's Surgical Center in Louisville. And we have 3 cases representing the clinic challenging different abortion restrictions right now that are at various stages in the courts. And that includes a requirement that abortion providers must have a written transfer agreement with a hospital, which is the case that you mentioned, which is the TRAP case, which we won in the district court after a trial, and the state of Kentucky appealed to the Sixth Circuit, and we're in the middle of briefing that right now. Kentucky also has a method ban, and it would prohibit abortions after about the 15th week in pregnancy, and we had a trial recently in that case, and the law is blocked in the meantime. There's also a law that we challenged in 2017 after it was passed by the legislature that was a mandatory ultrasound requirement and forced the doctor to show the image to the woman and describe the image as well, even if the patient did not want that information. And we got that law struck down in the district court, and my colleague argued it in front of the Sixth Circuit, and we're waiting for a decision on appeal there as well. And the Kentucky legislature is in session, and they are very busy trying to pass even more restrictions on abortion. I think that there are about 5 anti-abortion bills pending right now, including a ban on abortion starting at 6 weeks in pregnancy. So Governor Bevin and the anti-abortion politicians in Kentucky are doing everything that they possibly can to try to close the last clinic in Kentucky.
So I know there are a number of 6-week bans that have been attempted to put in place that have been struck down. Are there any that are seeing movement moving up, or have they basically just all been blocked?
So they've been blocked so far, and then I'll talk about the ones in the works. So a number of years ago, North Dakota had a 6-week ban that the Center for Reproductive Rights challenged and struck it down. And the Eighth Circuit Court of Appeals agreed that it was unconstitutional, and the Supreme Court denied review. That was, I think, about 3 years ago. Iowa passed a 6-week ban, and Planned Parenthood and the ACLU of Iowa challenged it, and just challenged it under the state constitution, and got it permanently blocked by the trial court, and the state has not appealed. So that 6-week ban in Iowa is struck down. Mississippi passed this legislative session a ban on abortion starting at 6 weeks. It does not take effect until July 1, absent, court challenge. So the Center for Reproductive Rights represents the last clinic in Mississippi, and I would guess that they would be challenging that law on behalf of the clinic there. And then there are a number of states that are considering passing 6-week bans, including Kentucky, Ohio, Tennessee, Georgia, Texas, Missouri are the ones that come to my mind off the top of my head.
Yeah, I mean, that one feels the most direct attack on Roe. I mean, 6 weeks is before most women know they're pregnant.
That's exactly right. And, they're doing this on purpose. The sponsor of the Ohio bill has said explicitly that she wants this to be a vehicle for the Supreme Court to consider overturning Roe versus Wade. And so these states are considering passing these blatantly unconstitutional laws as a way of testing directly Roe versus Wade. So we have both these frontal attacks on Roe and these restrictions that chip away at Roe that would eliminate abortion access if they're upheld. And that's why, when we started this conversation, the need for people to be vigilant on both levels is so incredibly important.
Absolutely. You have the challenges at Roe, the trap laws that are trying to close the clinics. There's just so much happening that everyone is so focused on Roe, which they should be. But I think going back to a conversation earlier where Roe is already in so many places not the lived reality on the ground, that it doesn't take the overturning of Roe to block people's access to services.
And that's the reality today for many women and people seeking abortion.
So I think that leads us to the big question that I know there is no answer for. Kind of with what you kind of see with the court, would you imagine there would be like a big, just like complete overturning of Roe? Or do you just kind of see continuing on the path we're on where it's just this death of 1,000 cuts?
Yeah, it's a good question, and I don't know the answer. We don't have a crystal ball, but I think it's more probable, at least in the short term, for a weakening and undermining of Roe versus Wade, and again, paying lip service to maintaining Roe, but creating a new standard of review for abortion restrictions that allows courts to uphold restrictions that would close clinic doors, eliminate access to abortion in the state entirely, but having the court just not say that they're overruling Roe. So I think that is more probable in the short term, but, we just don't know.
Right. I mean, the good news is with all of these attacks, there are states that are taking positive steps to enshrine Roe within their own state, but so far they've definitely been outnumbered by the states attacking Roe.
That's right. But also not just enshrining Roe, but also making proactive attempts to eliminate all restrictions on abortion, ensure that advanced practice clinicians can provide abortion in addition to doctors, really just taking down as many barriers as possible in those states is also incredibly important and proactive work that we all must be committed to doing, as well as fighting all of the defensive battles.
Well, that transitions perfectly into, I always like to end with, what can our listeners do to fight back? I think you hear about all these horrible things happening, and people really would love actions they can take. So what do you recommend?
I mean, there's really so much, and I think it depends on what people want to do and where they live and how they want to engage. Obviously, if you live in a state that is considering passing abortion restrictions, get involved in your state legislature. Similarly, if you live in a state where you think that abortion access is on fairly solid ground, but you could do more to eliminate any of the barriers that exist to make sure it would be a place where people can come for abortion access and not face obstacles, that's another way to get involved. And so, finding out in your community who's doing that work and plugging in with them, whether it's the ACLU affiliate, the Planned Parenthood affiliate, the NARAL affiliate. So figuring out that coalition partners that we have in the states and getting involved in the legislative work, calling your representatives and really engaging in the political process in that way. There's also volunteer opportunities in your community. I think that abortion funds are amazing and are such a critical, important part of people's ability to access abortion when they don't have the money to do so. So whether it's donating to any of these organizations or volunteering, that's another thing that they can do. If you are an attorney and are in a state where there is a parental involvement law, you can volunteer with an organization to go with minors to court to get a bypass of the parental consent requirement. And as I mentioned, Jane's Due Process in Texas is one of these organizations that works with a network of lawyers to do this. So those are, I think, just some of the ways that people can get involved. But I think figure out who's doing the work in your community and see how you can be helpful, whether it's volunteering your time, calling your state legislators, and then there's the federal government too. What's going on with your senators and your House representatives, and making sure that they know where you stand on abortion access is incredibly important.
Thanks so much for doing this, Brigitte. I really appreciate having this talk today.
Thank you so much for having me.
For more information, including show notes from this episode and previous episodes, please visit our website at rePROsFightBack.com. You can also find us on Facebook and Twitter at rePROs Fight Back. If you like our show, please help others find it by sharing it with your friends and subscribing, rating, and reviewing us on iTunes. Thanks for listening.